Can I skip the provisional and go straight to the non-provisional? Yes, you can. There is no requirement that you file a provisional patent application, but it does offer some benefits. The benefits of the provisional include cost. It is much less expensive to file a provisional patent application than it is to file a non-provisional patent application. So if you have an invention and you want to protect it while you're seeing whether there is any market interest, then a provisional allows you to do that without the cost of a non-provisional. There is a caveat to that, which I will get to a little later in the video. The provisional patent application also provides you with an international filing date so that you can claim priority to that application at a later date. That can be helpful for foreign filings. The provisional patent application also indirectly provides you with an additional year of patent protection. Typically, you get 20 years from the date of filing a patent, but as long as you file it correctly, the provisional will not count against you for that 20 years. It'll be measured from the date of filing of the non-provisional. The provisional also allows you to potentially make any changes to the invention and then update that information in the non-provisional patent application. So what are some of the downsides? Well, some of the downsides include, as I just mentioned above, as a benefit that you can change the patent application. This is also a downside because if you do make changes to your invention, then you probably won't get credit for those changes in the priority date from the provisional, just as of the date of filing of the non-provisional. It's a little confusing, but it's both a benefit and a downside. Another downside of the provisional is that it is never examined by the U.S. Patent and Trademark Office and will never issue as a patent. This is often one of the hardest things for my clients to understand. After I file a provisional patent application a couple months later, they'll come back and ask me how it's processing. And I have to explain that the provisional patent application is really just a placeholder. It's never examined. And then another downside is that if you do file the non-provisional after filing a provisional, that step does add cost and it can add some time to the patent process as well. So that can be considered a downside. So how do you know which is the right one for you, the provisional patent application or the non-provisional patent application? Well, for most of my clients who are individuals or small and medium-sized enterprises, it makes sense to start out with the provisional. In some cases, if you're completely finalized with the invention, you've already started selling it, you're not really worried about marketability because you know it's flying off the shelf already, then going straight for the non-provisional can be your best bet in order to save time and money. If you would like to learn more about provisional or non-provisional patent applications or patents in general, you can learn more at Pirate Fight Club, or you can schedule an initial consultation with me.